The piggybacking opponent. So here's the situation. Your side has put a lot of time, thought, and money into preparing a quality digital trial presentation, and the other side hasn't. But during the trial, the other side begins to see the value in your presentation, and they come to realize that they're being outclassed. This has happened to me so many times. So in front of the jury, they start asking your hot seat tech to bring up exhibits on the screen while they examine witnesses. So what do? You're in front of the jury. You can't really object or it'll make you look bad. So here are a few options. Be magnanimous. Usually, opposing counsel will look at the tech and ask them to bring up the exhibit in front of the jury. But before doing anything, the tech should look at their lead attorney to get permission first. It should just be a nod or something like that. Some visual cue where the jury can appreciate it. And they should do that before putting anything up on the screen for the other side. Let your attorney look magnanimous in front of the jury. Outside the presence of the jury, argue to the judge that it's your client's work product. Opposing counsel can use the hard copies or visual presenter if the court has one available. But why should opposing counsel benefit from your client's investment? Make the work product argument preemptively to the judge before trial even begins, so that you're not put in that situation where you're in front of a jury. If you have not yet or don't want to bring the issue up with the judge for whatever reason, another tactic that I have employed as a hot seat tech is to take a long bathroom break or make myself scarce when opposing counsel is set to begin their examination of a witness. That way, my attorney can always claim ignorance as to how to work the trial presentation software. I once worked in a trial where I called up a few exhibits on the screen for an attorney on the other side, thinking that it would be a nice gesture that would resonate with the jury. But it quickly became a habit, which started to blur the jury's perception of who actually owned the digital work product. So I began to make myself scarce. This helped maintain our strategic advantage. Another option is actually to share the information freely with your opposition and split the equipment and hot seat tech's labor costs. I don't recommend working for both sides if you're a hot seat tech, because ultimately you may be put into a position where there's a conflict of interest. So beware of that.